Hi, and welcome back to the Appellate Practice and Procedure course at Solo Practice University. We are on our seventh class, beginning our seventh class today, and our topic is Rehearing and Higher Court Review. We've been through more or less the entire appellate process now. You have gotten a decision from the appellate court, and we're on to the phase of the case where you've advised your client or are in the process of advising your client what to do after getting that decision. Looking at the introduction slide, that's the first point there. And so you get that decision, and it either goes your way or it doesn't go your way, and you've notified your client of the outcome of the case, as we discussed at the end of the last lecture. And so the question is, what are the next steps? What do you need to do or to consider in advising your client moving forward? And along those lines, what factors should you look into in advising your client? So moving on to the next slide, next steps for the losing party. And of course, you're going to look at this issue from two different sides. You're going to look at it, if you're the winning party, your lens that you're going to consider what to do next through is going to be one way. If you're the winning party, it's going to be something completely different. It's a different dynamic, totally. So a lot of these comments are couched sort of on the assumption that you're the losing party and needing to actually evaluate what's going to happen next. But I'll make clear when that is not the case. So the next steps for the losing party after you have obtained a decision from the intermediate appellate court or court of appeals. Well, one option would be to do nothing and let the decision become final and just stand as is. There may be circumstances under which that would be appropriate. Another possible step would be a motion for rehearing, or in some jurisdictions what's called a motion for reconsideration or a petition for reconsideration. In federal appellate practice, it's generally a petition for panel rehearing. Lots of different terminologies to use to describe what is basically a motion asking the intermediate appellate court to reconsider or rehear the case and reach a different result, or do something else that we'll get into here momentarily. And of course, another option besides do nothing or file a motion for rehearing is to seek higher court review, which is another focus of our presentation today. And that usually is going to be you're going to be looking at taking an appeal or equivalent proceeding to the state Supreme Court or equivalent, or the U.S. Supreme Court, of course. So for the winning party, the next steps would be just kind of wait and see what the losing party is going to do. Obviously, after engaging in the exercise of reporting the decision to the winning party, to your client as the winning party, there's not a lot of need to go in and spend a lot more time on the case, other than providing some initial level of analysis. And of course, most clients aren't going to want you to go and spend a ton of time and incur a lot of additional fees doing that. So the first logical thing to do, and a lot of this, the subject of our course today is logic, is to wait and see. If the opposing party follows the step of allowing the decision to become final, then there is not a great need to spend additional time, incur additional fees, taking further actions on behalf of the winning party. But if the losing party does appeal, what would you do as a prevailing party? Well, you're going to respond to, more than likely, or consider responding to whatever it is that the losing party files in whatever court it happens to file in, whether it files a motion for a hearing or equivalent in the Court of Appeals, or goes ahead and petitions the next higher court for review. So wherever they file it, that's where your next step is going to take place, as the winning party. Now, let's talk about motions for rehearing. We have a slide with that as the title, Motion for Rehearing. And the first question is, why would you bring one? There are a number of reasons to bring a motion for rehearing. And this, of course, assumes that you've gone through with your client and discussed that there's a need for, or possible need for additional action. And this is the action that they elect to take. There's no reason, or they elect not to, rather, just allow the decision to become final. You're going to do something to take further action on your client's behalf to try and affect the outcome. So the possibilities are, as we've got listed out here in the bullet points, one thing would be to correct problems with the appellate court's opinion or judgment. Sometimes a judgment is the easiest example to come up with of this situation, in which the court, for example, miscalculated the damages. If there's some modification, say for example, to the judgment in the trial court, and the appellate court didn't get its math right, then that would be one reason to file a motion for rehearing to ask the court to correct that error and reissue its opinion, or issue a different opinion with the correct numbers in it. There can also sometimes be other types of problems a little different than that might warrant a motion for rehearing, such as mistakes of fact. If the court recites facts that are clearly contrary to what the record says or what the parties have agreed to, or bases its analysis of an issue on a misapprehension of some fact. That would be another sufficient reason that would really just involve, well, I guess you could look at that a couple different ways. Some of those kinds of issues involve minor changes to the court's opinion that won't necessarily affect the outcome, or at least the big picture outcome, but in some way, the point is that you're asking the court to make some changes that do alter the ultimate outcome somehow. The second major reason for filing a motion for rehearing is to actually go beyond merely correcting some mistakes on the face of the opinion, and to try and get the Court of Appeals to change the result. Usually the approach there is to say that the court made some error in its analysis beyond just a few facts that may or may not be significant, or it could involve that kind of analysis as well. It just depends. It's very fact specific based on what the opinion itself says. But again, the best example of that kind of situation is when you believe the Court of Appeals has made an error in its legal analysis of the issues in the case, and if the court were to alter that analysis and adopt the analysis that you would like it to adopt, then that would in fact change the outcome of the case. In some jurisdictions, this may still be the case. It used to be the case here in Texas, but following along with that third bullet there, you might need to file a motion for rehearing to preserve error in the Court of Appeals for higher court review. That for many years, that was a practice in Texas, where if you were intending to take an appeal, at that time it was called an application for writ of error, to the Supreme Court of Texas, then you actually had to file a motion for rehearing in the Court of Appeals and raise the points that you intended to pursue in the Supreme Court to preserve error, much like you would in a trial court. Texas, about 12 years ago, changed its practice from this writ of error practice to what's now a petition for review practice. And one of the major changes that was made at that time with those rule changes involved doing away with the requirement that points be raised in a motion for a hearing as a precondition to raising them in the Court of Appeals. So that's not a requirement here any longer. I think there are probably jurisdictions out there that still do require that. And again, I'll fall back on my party line that I've used over and over during this course, which is be sure and check your local jurisdiction's rules to know whether that's the case. The fourth reason to file a motion for rehearing would be to invoke the court's en banc jurisdiction if you have more than a panel of judges that sits on the court. We have a number of courts here that have, while the courts initially sit in panels of 3 generally, some of our courts have more than 10, more than 12 even, justices on them. And if you have an issue that involves needing to preserve uniformity in the law, or either between courts or within the decisions of the same court, there usually is a process for filing a motion asking the entire court to hear the case, and that could, if you're able to persuade the entire court to hear this. Is there, in looking at what's going on in the particular court you would be taking the next level of appeal to, can you discern any particular trends in that court? Are they granting relief on certain types of cases more often than others? Jury trials in personal injury cases, for example, summary judgment. The case, it could very well change the outcome as opposed to the decision that was made, say, by a panel of 3 justices, which is the ordinary way that appeals are decided here in Texas, certainly, and most, I believe, circuit courts, federal circuit courts as well. You get an opportunity to ask a larger body of justices on the same court to review the case, review the issues, and decide the merits of the case. And if there's dispute about what the law is within the jurisdiction, within the law of that appellate court as it's been decided, and the law of the broader jurisdiction, say the state of Texas versus the Austin Court of Appeals, then the en banc court, in reviewing that, may decide the case differently to try and bring the case either in line with other decisions from the same court or in line with sister courts in that jurisdiction. As far as a practice pointer for filing motions for rehearing, it is not appropriate to simply rehash arguments that you've already made. You're going to lose that motion every time, and really it winds up being a waste not only of your client's resources to the extent your client has had to pay additional fees to you to file that motion, but it occupies the time and attention of the court staff, court attorneys, and even the justices when those kinds of motions are brought. So don't simply rehash the arguments you've already made in your brief. A meritorious motion for rehearing will generally raise something new, and it will either be, as I've spoken of before, something that was raised by the court's analysis in its original opinion, or it could be something such as an intervening decision from another court or from, say, a higher court that might have an impact on the case, and the justices in the intermediate appellate court did not have the benefit of that decision at the time the decision was made, or at the time your case was decided, to be a little bit clearer about that. And of course, one approach, a good approach to these issues, is to keep yourselves abreast of the latest authorities and bring them to the court's attention before such time as the case is decided. It's not always possible to do that. So if you've got, for example, a Supreme Court decision that comes out, the day after your case is decided by the Court of Appeals, then it's certainly appropriate to bring that up as an issue in a motion for rehearing and to point out, say, look, Court of Appeals, you didn't have the benefit of this decision when you decided the case, and therefore you ought to rehear it, reconsider it in light of this decision, and hopefully if you're the party that lost based on the initial ruling of the appellate court, you can make a case for why that changes the outcome and you ought to win. There are some downsides, just generally, to filing a motion for rehearing. Even if you have a meritorious motion, it does usually wind up costing the client some additional money, unless you've got some other fee arrangement where the cost of a rehearing motion is built into what's already been paid, or you're handling the case on a contingency. So it is, to some degree, one more brief that the party has to pay for, and you have copy costs and binding costs and all the ordinary things you would have in filing a brief. And so there's at least some additional cost in most cases to the client, and that is a potential downside. Another potential downside is to be careful when you file a motion for rehearing, because it could actually delay significantly the finality of the case. I've seen cases in which party files a motion for rehearing, Court of Appeals doesn't seemingly doesn't do anything, when in fact it's probably working behind the scenes, but the case basically disappears back into the decision hopper, and the parties don't receive notice of anything going on, and then next thing you know, in some set of orders, 6 months from now, a new opinion is released, and that new opinion may reach the same result as before. If the court ultimately denies the motion, or even if it's granted or granted in part, the result may still be the same, and it's just the analysis that would have changed. So if your client has a sensitivity to the speed with which the appeal is decided, then take that into consideration before recommending and filing a motion for rehearing. All right, so what about from the standpoint of the prevailing party on the appeal? What are the things to consider when opposing a motion for rehearing? And that next slide, as is indicated there, sometimes the best response is no response at all. Again, it depends on, in large part, what your local practice is. But if your rules say something to the effect of there's no response required unless the court requests one, and particularly if they even go farther than that and say the court won't act on or grant relief on a motion for rehearing unless a response is requested, then you can take some comfort in advising your client that there's no action necessary even after a motion for rehearing is filed, because you at least have, in theory, and there are mistakes made from time to time, but in theory you have the assurance that the court's not going to grant relief without hearing from your side. And that, by taking that position and taking that approach, you avoid incurring any additional expense for the client, as we were speaking about earlier. Another legitimate response, in opposing a motion for rehearing is to just, if it's true, say that the motion really doesn't say anything new, that the movement really has just rehashed old arguments or maybe repackaged old arguments, and in a hope of trying to catch someone's attention and somehow get a different result, which is very, very unlikely. It can be a compelling argument in response to a motion for rehearing, even if it appears on the surface that it might have some merit, that the movement really hasn't raised any argument that hasn't been considered and even rejected by the Court of Appeals before. So consider raising that in opposition to a motion for rehearing if your case warrants that. And then finally, of course, there's the situation in which it would be appropriate and maybe even necessary to rise up and meet the movement's arguments with substantive arguments of your own. And that's, of course, going to depend on the case. It's going to depend on what kinds of arguments that the movement raises. For example, you can show why the intervening case doesn't apply in your situation and why the result stays the same. It's just a matter of making arguments in opposition to the arguments that the movement has made and persuading the Court of Appeals that the result ought to stay the same. Another option that is not mentioned in the slides is you may in fact agree as a non-movement that there's been a math mistake, or that there's some error in the court's opinion that ought to be fixed. And if that's the situation, you can do one of two things. You can either agree with the motion for rehearing, and in some rare circumstances maybe even file it as an agreed motion if it's just an egregious error, or otherwise just file a response that says, the movement is right, this change ought to be made. We don't agree with changing anything else in the judgment or in the opinion, but this is something that the court ought to consider. So that's pretty much a nutshell approach to motions for rehearing. It is not an opportunity to simply rebrief the case and make the same old arguments again. And frankly, if it's not jurisdictional, you have to consider whether it's worth your client's time and effort to do it. It is in some situations, but not in every case. And the judicious appellate lawyer will make judgments. The smart, experienced appellate lawyer will make judgments and will advise his or her clients about when it's appropriate to file a motion for rehearing, including, what the odds are of getting a motion granted versus the advantages and disadvantages to just skipping that process and either allowing the opinion to become final as it is or pursuing higher court review, which is what we're going to move on to now. All right, should a party pursue higher court review? Well, the first question to ask in trying to answer that question is, what are the chances that the higher court is actually going to hear the case? There are a number of ways of evaluating your potential chances of obtaining relief in the higher court. One is to look at any available statistics. Sometimes, either the courts through the local Office of Court Administration or sometimes practitioners will take a look at statistics that the court has released over time and where these folks have evaluated, or at least it can be drawn from those statistics, the pure numerical chances of actually getting a petition, let's just call it a petition, granted. For example, in our state, in Texas, the number has fluctuated some within the last 10 years, but in the last few years I think it's hovered at about 13%, which is not a very large number. Certainly something to consider when advising your client is just from a purely statistical standpoint. The chances are about 87% that you are not going to get even the petition heard, much less get any relief granted that you would be requesting. So that's something to factor in, although you certainly have to consider the details of the case. And that's where we kind of get into the next couple of points. Is there, in looking at what's going on in the particular court you would be taking the next level of appeal to, can you discern any particular trends in that court? Are they granting relief on certain types of cases more often than others? Jury trials in personal injury cases, for example, summary judgments, breach of contract cases. Are you able to tell whether the odds increase or decrease based on the type of case or other trends that you can see from what's going on in that court? And then I think another major issue for helping to evaluate whether to pursue relief is, has the court recently decided cases involving similar issues to your case, or are there already other cases pending that the court has decided to hear or that are otherwise on the court's docket that involve issues that are similar to yours? And of course, if there are, those cases need to be brought to the forefront of your petition for review or certiorari if you were in the Supreme Court, and used to your advantage to try and bolster your opportunities, your chances of obtaining higher court review. From the court's perspective, what kinds of things would the court look for in deciding whether to grant review of a particular case? Well, these examples in this slide, I've got a number of examples listed here that really are particular to Texas practice, but I think that they apply generally across the board and would be a good starting point to consider in structuring the argument in your brief and how persuasive you can make it with these considerations in mind. The first is whether your high court has discretionary jurisdiction or its review is a matter of right. It's never been reviewed, at least according to the Supreme Court of Texas, it's never been reviewed as a matter of right for any party who brings a matter before that court. It's always been discretionary, and that did not change, and in fact was only enhanced when the court changed over from the old application for writ of error practice to the petition for review practice. Most of us know that the Supreme Court of the United States has discretionary jurisdiction. It picks and chooses the cases that it wants to hear. And when the Supreme Court made the change from the petition to the petition for review practice back a number of years ago, it was emulating the Supreme Court, the U.S. Supreme Court model, to make clearer in some ways that its jurisdiction was discretionary, and that it really, what it wanted to do was take cases that it thought it ought to take, and not cases that, just whoever brought the case to the court could get an EO case heard. That's never been the case in either the U.S. Supreme Court, as far as I know, or the Texas Supreme Court. So consider, if you've got an appeal as a matter of right, then that's going to potentially alter your strategy in terms of whether you advise your client to pursue additional appellate review or not, and then maybe even some of the arguments that you make. So another factor to consider that I think telegraphs to the higher court that this is a case it ought to look at is whether there's a dissenting opinion in the intermediate appellate court. That is an issue that the Texas Supreme Court considers expressly in terms of granting relief in cases. It increases your chances of getting a petition granted if there is a dissent in the lower court, and especially if there's a vibrant debate on the legal issues and a sharp disagreement on the legal issues between the majority opinion and the dissent. Also, the third bullet point there, do the lower court's opinions conflict? What that really, I could say that a little bit better. What it means is among courts of the same level in that jurisdiction, such as the Fifth Circuit versus the Second Circuit or the 11th Circuit, are they ruling differently on issues of law that are otherwise the same? The factual setup is the same. The only thing that really changes the outcome is the law. And if you can demonstrate in your jurisdiction that you've got, in your decision, it's come out differently than a decision in a different part of a court of appeals that has jurisdiction over cases coming out of a different part of the state, then you can, I think, probably increase your chances of persuading your higher court that it ought to take review because it needs to resolve the conflict. Other factors that the courts consider, at least certainly here in Texas and I think elsewhere, are whether the case involves an issue of statutory construction, because statutes are applied everywhere, and sometimes when they first come out there can be differences of opinion in how they should be applied. After they've been on the books for a while, it's a little different story. The jurisprudence tends to evolve. The cases will interpret the statute and will hopefully arrive at a uniform conclusion on how the statute ought to be interpreted. Sometimes that doesn't happen, and you wind up with divergent views on statutory construction. And if that does turn out to be the case, then there again is another reason to articulate as to why the higher court ought to hear the case, is to resolve that conflict, not only because it's a conflict, but also because you've got a statute that's out there affecting any number of people, and it's important that the conflict in the construction be resolved. You can also argue that it's just an important issue. If it's a constitutional question, those are kind of nice, sexy issues. But even if it's something as mundane as say premises liability cases or negligence cases, if it's going to change, if the result in your case and the law as stated by the intermediate appellate court is a departure from something else that's been done in other cases and is likely to recur is probably the best way of phrasing it, then you can make the case that, look, this issue is going to come up again, and other appellate courts are going to look at what happened in our case and are going to reach the wrong result because the court got the law wrong and applied it incorrectly. So, Supreme Court, you ought to grant review in this case and consider it and decide it our way to deal with an issue that's going to be repetitive over and over again in the jurisdiction of this state, or just in the jurisdiction generally. And finally, another factor that can come into play is whether your reviewing court, the high court, engages in error correction, or if it, again, this ties into the first bullet point here, if it engages in discretionary review. Some, along the lines of the certiorari jurisdiction that we discussed a few minutes ago, some courts don't consider themselves to be error-correcting courts, and so it's not particularly persuasive to them to go in and say, well, the Court of Appeals just got it wrong, without being able to demonstrate, one of the other factors that we've discussed here, such as that, there's a conflict between that decision and other decisions that would result in instability in the law in your state. So consider very carefully and consider the practice in your locality as to whether the high court considers itself duty-bound to correct errors that the intermediate courts commit, or whether that is not something that you want to emphasize, just rather emphasize the importance of the issue, and that it's going to affect future litigants a whole lot more than just the parties to your case. All right, next slide on higher court review. These are other factors to consider. Again, much like with motion for rehearing, there are going to be additional costs in pursuing higher court review. You've got a client by this point who most likely, depending on the fee agreement, it will have spent a lot of money, and it's always a lot of money because appeals aren't cheap, even if it's a smaller case. They've spent a lot of money to take the case all the way through. They've been through a full-blown appeal. How much more can they take? Are they upside down? Basically, it's a kind of a bad analogy, but they have to look at the opportunity costs and continue to pursue it relative to what they could get out of it, or what the cost otherwise would be. And sometimes the client has to ask the question, knowing that there are going to be additional costs, whether it makes sense to continue pursuing the matter. And there are times when the best option is much like at the beginning when we were talking about motions for rehearing, whether to pursue a motion for rehearing. Sometimes the best option is to just come to accept the reality of the Court of Appeals decision if you think the odds are too great and the costs are too high, or the client does after you've informed them about it, and just cut your losses and move on. Another major issue in making this decision is if you're representing a client that's been ordered to pay a large judgment, and maybe even been ordered to pay the other side's attorney's fees on appeal, maybe even attorney's fees for each level of appellate review, the delay that can be added by taking an appeal to a higher court can be substantial. As I point out in the last line here, even if the case is resolved on the merits, sometimes it can take years, and that's a long time to be in the court system. And if you're sitting on or opposing a judgment that's a considerable money judgment with interest running at whatever the rate is in your locality, let's say 5%, 6%, 8%, whatever, on $1 million judgment, that can stack up pretty quickly. And so the client may decide, even if review is granted, if I lose, I'm going to wind up paying not only $1 million, but $1 million plus 5% interest. And if we expect the appeal to last, if it's granted, it could take a year or 2 years to get it decided, I'm going to owe that much more, or our company is going to owe that much more. And so maybe we just decide to try and resolve the case, give up filing a new a petition for review to the next level in exchange for some kind of discount on the judgment, for example. And same thing with attorney's fees. I mean, appellate attorney's fees, depending on the case, can be substantial and could be added on at the next level of appeal. And so you could have a scenario where you've got $1 million judgment, interest on that, plus $30,000, $40,000, $50,000 in additional appellate fees, and before you know it, you're really you're quite a bit up above the original amount of the judgment just based on the passage of time. And if the odds of obtaining relief are not great enough, or if the issue is not important enough to your client to pursue that despite those risks, then it may be time to just allow the Court of Appeals judgment to become final and either pay it or work out some resolution with the other side. Of course, you can also look at that issue, the issue of delayed resolution, from the standpoint of a party who is pursuing that relief. And sometimes closure, even if you don't prevail, and even if you're going to lose, you've lost a judgment, a money judgment, but you've been fighting the case for, sometimes 5, 6, 7 years. Sometimes the best thing to do is just to, as I said, cut your losses and move on. These are very fact-specific scenarios. You've got to consider, the nature of the client. Is it an individual or a business? Do they have a budget for this kind of thing? Do they have the money to move on? Do they have the money to pay to fight? What's going to be the impact on the bottom line for them long term, under the different scenarios that would be possible? And sometimes the delayed resolution, it could result, if you take an appeal and lose, isn't worth it. And sometimes even if you take an appeal and you win, there's still the additional costs that go along with pursuing that relief. And so, it's again very fact specific, very case by case, but you just got to consider all these factors in advising your client whether to move ahead with the petition to the next higher court. All right, so you decided to do it. You've decided to take a petition, we'll call it just a petition generally, to the Supreme Court of your jurisdiction or the United States. So what are your basic strategies? Well, aside from just the practical cost, the monetary costs and so forth, you have to look at your issues and just confirm that you can actually make a good case to get a different outcome if you're the petitioner. And if you can consider all the factors that we've discussed, it's an important issue to the jurisprudence. Cost, it makes sense for the client if you move ahead, and so on. Then, if you can make that good case, then your chances of getting review are probably greater than just the average statistical chance. But you've always got to ask the question of whether moving ahead is in your client's best interest. That is always the guiding factor, is whether it's in the client's best interest. And the client informs that decision, the client drives it, but your job as a lawyer is to go over all the options. Your job as an appellate lawyer specifically is to evaluate the case, go over all these options, and advise the client on whether you think it's in the client's best interest to go forward, and then allow them to make the decision. Usually, especially in these times, economics is the biggest consideration. What's going to be the effect on the bottom line. As far as respondents are concerned, the basic strategy is, if you've got a situation, moving to the next slide, where the court has discretionary jurisdiction, you may not need to get into a bunch of substantive briefing. Depending on how your briefing structure, if you have multiple briefs, petition, then a brief on the merits and so forth, like we have in Texas, your first job may be to convince the court why it just shouldn't hear the case. Not that it should decide the case one way or the other, but just that it shouldn't hear the case, period. And some of the arguments to consider making in approaching from the respondent's position the case is, for example, as we've got listed here, the petitioner, they're making this really interesting argument. They've waived the error, and the court can't reach the interesting question that's been raised, and so the court ought to just deny the petition. That's a legitimate strategy to take, and it can be actually very persuasive. You can argue, if you need to get into the merits a little, you can argue, well, again, that's a very interesting argument, but the result that the Court of Appeals reached was ultimately correct, and so therefore, if the court got it right, you ought to leave it alone, Supreme Court, or alternatively, even if it was an error, the error was harmless. We talked a lot about harmless error in the briefing portions of this course, and so I would urge you to go back and look at those lectures to just be refreshed on harmless error and how to approach it in briefing. It's really the same basic strategy in responding to a petition, just to demonstrate that the error doesn't warrant reversal, even if it is error. You can argue, of course, that the case really isn't important to anybody but these parties. It's a fact-specific case. not going to affect anybody else. Therefore, really, if the court has discretionary jurisdiction, it should just let it slide. That sort of encompasses those two middle bullet points there. And also, of course, you can just take on the other basic reasons why a petitioner may assert that the petition ought to be granted. There's no real conflict. The petitioner asserts that there's a conflict either between the different courts of appeals in our jurisdiction or among the decisions of the same court. Well, that's a false conflict. And so demonstrate why those decisions can in fact be harmonized and why therefore it's not important. It's a case that the higher court ought not to consider. And then finally, going back to the issue of error correction, if the court doesn't consider itself, this is again tied to if you've got a fact-specific case, if you're in a jurisdiction where the court does not consider itself obligated to correct errors of the Court of Appeals, just say so. That the court's jurisdiction, the court is not an error-correcting court, and so therefore it ought not to grant the petition. You are talking about most of the time courts with finite resources. They can only grant so many cases per year. In Texas, I think our Supreme Court hears about 100 cases, 120 cases a year, and if you grant every case where there's arguably error shown, you're not going to be able to handle all the important ones. And so this is one that the court, I think the argument would go something like, this is one that the court just ought to let go, and you can't win them all. Otherwise, generally, from the respondent standpoint, I would recommend you go back and look at the briefing from the appellee's standpoint, as we discussed in the earlier lectures. The approach is pretty much the same. You're going to want to meet the arguments that the petitioner makes head on if review is granted. If you're talking about briefing on the merits, then that's really where you are. You're back to dealing with the merits of the arguments they make, the strength of the authorities that they cite, and so on in a full-blown brief, which, except for the extent to which the petitioner is still arguing about, say, jurisdiction or the importance of the case and that sort of thing, which you would want to respond to in a merits brief as well. The briefing strategy for a respondent is pretty much the same as for an appellee in the case. That pretty much wraps it up for lecture number 7. Next time in class number 8, which is the last of our series, we'll be talking about tips and strategies for marketing and appellate practice. And that is an area where I have received some inquiries from students in the course. By all means, if you've got questions in that area or any other, as always, contact me through the website. And if you do that, I'm going to address the questions that have been raised thus far in the next lecture with respect to marketing. Any questions that come between now and the next lecture, I'll deal with then as well. So until then, I really have appreciated your attention, and this has been a little bit tougher subject to present on than some of the others because it's a very narrow topic and it's very, very jurisdiction specific. And so I hope you've been able to take something away from this lecture and use it in your practice if you're working on building an appellate practice, as I hope you are. So until next time, thanks again for joining us, and I'll look forward to seeing you all for class number 8. Thanks.